Hello everyone, and welcome to Internet Law Review. For today's story, we are covering the Supreme Court case of Dawson v. Steager. This is a case dealing with taxation, which is an ever popular topic, particularly this time of year, as all of our taxes are about to be due. And this particular case deals with the authority of a state government to tax certain federal employees. So let's read this case and see what the United States government has to say about this matter. After petitioner James Dawson retired from the U.S. Marshal Service, his home state of West Virginia taxed his federal pension benefits as it does all former federal employees. The pension benefits of certain former state and local law enforcement employees, however, are exempt from state taxation. Mr. Dawson sued, alleging that the state statute violates the Intergovernmental Tax Immunity Doctrine codified in U.S. law. Under that statute, the United States consents to state taxation of pay or compensation of federal employees, but only if the state tax does not discriminate on the basis of the source of the pay or compensation. In other words, you can tax everybody, but you have to tax everybody. A West Virginia trial court found no significant differences between Mr. Dawson's job duties as a federal marshal and those of state and local law enforcement officers exempted from taxation, and held the state statute violates the anti-discrimination provision. Reversing, the West Virginia Supreme Court of Appeals emphasized that the state taxation exemption applies only to a narrow class of state retirees and was never intended to discriminate against former federal marshals. So the conflict is set up. The U.S. federal government says that you can tax everybody, and as long as you tax everyone, you can tax federal employees too. But if you exempt certain state employees, you may not be able to tax federal employees with similar jobs. So let's see what the U.S. Supreme Court has to say here. Held, the West Virginia statute unlawfully discriminates against Mr. Dawson as the United States law forbids. A state violates the statute when it treats a retired state employee more favorably than a retired federal employee, and there are no significant differences between the two classes that justify the differential treatment. Here, West Virginia expressly affords state law enforcement retirees a tax benefit that federal retirees cannot receive, and there are no significant differences between Mr. Dawson's former job responsibilities and those of tax-exempted state law enforcement. The narrow preference should be permitted, the state argues, because it affects too few people to meaningfully interfere with federal government operations. Section 111 of the federal law, however, disallows any state tax that discriminates against a federal officer or employee, not just those that seem especially cumbersome. And in Davis, the court refused a similar invitation to add unwritten qualifications to the federal law. That is not to say that the narrowness of a state tax exemption is irrelevant. If the state exempts only a narrow subset of state retirees, it can comply with the federal law by exempting only those of a comparable class of federal retirees. The state also argues that the statute is not intended to harm federal retirees, but to help certain state retirees. The state's interest in adopting the discriminatory tax, however, is simply irrelevant. For reasons other than job responsibilities, the state insists, retired U.S. Marshals and tax-exempt state law enforcement retirees are not similarly situated. But the state statute does not draw any such lines. It singles out for preferential treatment retirement plans associated with particular state law enforcement officers. The distinguishing characteristic of the retirement plans is the nature of the jobs previously held by retirees who may participate in them. The state trial court found no significant differences between Mr. Dawson's formal job responsibilities as a U.S. Marshal and those of a state law enforcement retiree who qualified for the state tax exemption. And the West Virginia Supreme Court of Appeals did not upset that finding. By submitting that Mr. Dawson's former job responsibilities are also similar to those of other state law enforcement retirees who do not qualify for a tax exemption, the state mistakes the nature of the inquiry. The relevant question under the federal statute is not whether federal retirees are similarly situated to state retirees who do not receive a tax break. It is whether they are similarly situated to those who do. Finally, the state says that the real distinction may not be based on the job duties at all, but on the relative generosity of the pension benefits. The statute, as enacted, however, does not classify persons or groups on that basis, and an implicit but lawful distinction cannot save an express and unlawful one. Reversed and remanded, Justice Gorsuch writing on behalf of a united and unanimous Supreme Court. So, that's the factual background. The federal government has said that you can tax federal employees as long as you tax state employees or other persons to the same degree. And that makes sense. And if you want to exempt your own state employees, you have to exempt similarly situated federal employees. Also seems logical. So if the state wants to say, for example, that state law enforcement officers should be exempt from state level taxes, certainly a reasonable argument, at least in theory, because perhaps it provides an additional incentive for people to become law enforcement officers. And if the state needs law enforcement officers, exempting them from certain taxes would certainly be a motivation enough. But if you're going to do that, you have to provide the same courtesy to federal employees as well. The state government, when it's setting up its tax schemes, cannot unduly favor a state level government, and the fact that so few people are being impacted is irrelevant. The only question is, are there federal employees who are not receiving the benefit of comparable state level employees, no matter how few state level employees there may happen to be? But that's all on this issue for now. I hope you're well, and until later, cheers and goodbye.